This is Mr. Lim, the owner of a successful electronics retail store in Malaysia. He was looking to sell his business and retire. He entered into negotiations with Ms. Tan, an aspiring entrepreneur who expressed interest in purchasing the goodwill of his business. As part of the sale agreement, Mr. Lim insisted on including a clause that prohibited Ms. Tan from engaging in a similar business within the same city for a period of 5 years after the sale. Ms. Tan, eager to acquire the established customer base of Mr. Lim's business, agreed to the clause without fully understanding its implications. However, she later became concerned about the legality of such a restrained trade clause. Subsequently, Ms. Tan hired Mr. Ahmad as a sales manager for the newly acquired electronic retail store. As part of his employment contract, Mr. Ahmad agreed not to work for any competing electronic stores within a 10-kilometer radius of the business premises for the duration of his employment and for a period of 2 years after its termination. Mr. Ahmad, excited about the opportunity to advance his career, signed the contract without considering the implications of the non-complete clause. However, he later began to question the enforceability of such a restriction and its potential impact on his future job prospects. Hence, Ms. Tan and Mr. Ahmad came to your legal firm to seek for advice.
Section 28 stated that every agreement by which anyone is restrained from exercising a lawful possession, trade, or business of any kind is to the extent void. However, there are some exceptions which make the clause of the restraint valid. For example, Exception 1 stated that a person who sells the goodwill of a business may agree with the buyer with the restraint of carrying on a similar business within specified local limits, but the limits must appear to the court reasonable. And the next exception is the partners, upon the dissolution of the partnership, may agree with the restraint of not carry on the business similar to that of the partnership within such local limits as referred to the Exception 1.
Next, in the case of Nagadevan anak lelaki Mahalingam against Millennium Medical Services, the facts include appellant become a partner for the respondent firm pursuant to a partnership agreement. Appellant also was restrained from exercising his right from practicing as a medical practitioner within a radius of 15 km of any partnership clinic. The court held that the clause was void. This is because the appellant was not a partner at the time of the execution of the agreement. Appellant was only admitted as a partner pursuant to the agreement. According to Section 28, Exception 2, it does only apply to an agreement made between the partners when the same was made upon or in anticipation of the dissolution of the partnership. But in the present case, the appellant was not a partner of the respondent firm at the time of the execution of the agreement and was only admitted as a partner pursuant to the agreement. Since the appellant was not even a partner when he entered into the agreement, it could not be said that the agreement was made in anticipation of the dissolution.
Potential legal implications mean the probability of the consequences of being involved in something according to the law. The implications can either be positive or negative. Referring to the question, if Ms. Tan and Mr. Ahmad were to challenge the legality of the restraint of trade clauses, the legal implications would depend on their situation and the clauses itself. In the first situation of Mr. Lim and Ms. Tan, Mr. Lim imposed a restraint of trade clause in the sale agreement that prohibited Ms. Tan from engaging in a similar business within the same city for a period of 5 years after the sale. According to Section 28 of the Contracts Act 1950, it is stipulated that this kind of restraint of trade would be void. However, there are exceptions to that section, and Exception 1, which is the saving of agreement not to carry on business of which goodwill is sold, would be similar to Ms. Tan's situation. In that exception, it is stated that one who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within specified local limits so long as the buyer or any person deriving title to the goodwill from him carries on a light business. Hence, the restraint of trade clause imposed on Ms. Tan would be legal and valid in the contract. Therefore, there will be no potential legal implication for Mr. Lim, and Ms. Tan will not be liable for remedies and must comply with said clause. Regarding the remedies to be claimed differs from the situation itself. The remedy. The legal implication does not rise from the facts due to the exception of the restraint clause which is stated in the Contract Act 1950 itself. If Ms. Tan were to claim remedies from the court, there is no remedy that could be claimed by Ms. Tan due to the validity of Mr. Lim's restraint clause. Therefore, the contract would be valid and Ms. Tan must conform with the restraint clause made by Mr. Lim.
Moving on to the second situation between Ms. Tan and Mr. Ahmad, where Mr. Ahmad is the sales manager that was hired by Ms. Tan. In his employment contract, Mr. Ahmad was prohibited from working for any electronic stores within 10 kilometer radius of the business premises for the duration of his employment and for a period of 2 years after its termination. Pertaining the situation of Mr. Ahmad, if Mr. Ahmad were to challenge Ms. Tan, the most suitable provision that could be used is Section 28 of the Contract Act 1950, where it stated that this kind of restraint of trade clauses that prohibited anyone from exercising a lawful profession would be void, and the exception provided were only for sale of goodwill of business and also only for partnership. However, in this situation, there are no exception for the situation between an employer and employee. Thus, a lacuna was discovered. So, when there are lacuna, common law could be used to fill up the gaps. However, based on the Book of Principle of the Law of Contract in Malaysia, written by Dr. Syed Ahmad Assagoff, it is stipulated that this principle only can be used for the exception mentioned in Section 28. Therefore, no matter how, the restraint of trade would be void since it is done between employer-employee, rendering the clause to be illegal. We could also use the case of Stanford College Group Sdn Bhd against Raja Abdullah Raja Osman, where to apply to the situation, the clause made by Mr. Tan itself would affect the livelihood of Mr. Ahmad, as he couldn't work elsewhere within 10 kilometers of the plaintiff's store. And when in future Ms. Tan asked for injunction in court towards Mr. Ahmad, if he ever went to work within that 2 years of period, he would be liable for remedies. As for the remedies, we could see that the restraining clause made by Ms. Tan itself is void according to Section 28, and so when in the future prospect where Ms. Tan were to obtain an injunction toward Mr. Ahmad, if Mr. Ahmad were to claim for remedies by virtue of the case of Stanford College Group, Mr. Ahmad could apply to set aside the injunction made by Ms. Tan.
In the case of Stanford College and Raja Abdullah, the defendant works with the plaintiff as a lecturer in the plaintiff's college. There was an agreement stated that after 2 years of the defendant's termination, the defendant cannot work in any other institutions. However, after his termination, the defendant works with Syarikat PDC Sdn Bhd to teach hotel management. It was held that the court allowed the defendant's appeal to set aside the injunctions imposed on him. It was stated that the restraints set by the plaintiff threatens the livelihood of the defendant.
So, the question 3 is about the legal strategies and recommendation that seeks by Mrs. Tan and Ahmad. For the overview, due to the clause in the agreement, Mr. Lim, as the owner of the business, restrained Ms. Tan from enjoying the same nature of business for 5 years period and within the same city. The question is, what can we advise her? So in this problem, there are 2 recommendations that we believe is suitable for Mrs. Tan's condition. There are 2 recommendations that we state in our group. The first one is, as stated in exception 1 of section 28 of Contract Acts 1950, the transfer of the goodwill of the same business nature make the restraint clause valid. So, we advise Mrs. Tan to accept the legality of the clause and not to challenge the restraint clause. Due to the law, the restraint clause is valid because it falls under the exception 1 and the court respect to it as long as it is reasonable. Second, the recommendation that we suggest is the negotiation process. Negotiation is the process through which two or more parties deliberate over the terms of a contract to reach an agreement on how their relationship will operate and what their obligation will be. As long as it is accepted by both parties, the parties can still negotiate about the terms of the contract and they can agree upon the new obligation if it is fit and fair for both parties. Negotiation can be done as long as the flow of the law is followed.
In case of Mr. Ahmad and Ms. Tan, we can apply arbitration. Due to Malaysia's ratification of the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, commonly known as the New York Convention, arbitral awards made in Malaysia and enforceable in 148 other signatory nations. Instead of going to court, the parties choose arbitration as a private conflict settlement process. By agreement of the parties, a disagreement is presented to one or more arbitrators who render a legally binding decision on the matter. The Arbitration Act 2005, as amended by the Arbitration Amendment Act 2011, is the primary piece of legislation that governs arbitration in Malaysia, both domestically and internationally. The UN see-through model law serves as a close model for the Act. The examples of the arbitrators in Malaysia is the Kuala Lumpur Regional Arbitration Centre, Chartered Institute of Arbitrators, and also the Malaysian Institute of Arbitrators. In applying in this case, Mr. Ahmad and Mr. Tan, since there is no exception, falls under the section 28 of the restriction for the employer and the employee, then we can bring this issue to arbitration. So, Mr. Ahmad has to prove that non-compete clause is not valid and can be severance. In conclusion, by the invalid non-compete clause, hence Mr. Ahmad can fight this in the arbitration, and also it can be severance, and Mr. Ahmad can continue the contract without comply with those clause.